All right, everyone, we're going to go ahead and begin. Hello. We want to let you know ahead of time that this meeting will be recorded. It will also be uploaded to social media to promote our guidance. If you would like to change your name or turn off your camera, please do so now. We will open the chat for our Q&A session at the end of our event. And just to make sure, because of the nature of the law, we will be talking about weapons, violence, and assault. My name is Zach Gittrich. I am a founding member of the Central Illinois Research Collective. The Central Illinois Research Collective, also known as CIRC, is an organization focusing on accountability and transparency at all levels of our government. We are an all-volunteer organization. Our collective is made up of working-class individuals who strive to provide education on important legislation and policy initiatives that support the workers in our community. Our goal as a collective is to be a resource for organizers throughout Central Illinois. Our services include requesting public information, assisting individuals with police complaints, and providing critical information on new legislations and policies. If you would like to get involved in our collective, please submit your info to this Google form that we're going to go ahead and drop in the chat. Obviously, all are welcome. Today, we're very excited to hold our first major event with our partners, the Afro-Socialists of Color, Bloomington-Normal. This town hall on HB 3653. Just as a note, we have updated the guidance with additional information and will continue to update it as new laws are passed that alter or interact with HB 3653. You can always find the most up-to-date version of our guidance at this link that we are now posting in the chat. Before we begin, we will let each of today's presenters introduce themselves and say what organization they are with. And I'm going to go ahead and send it over to Nicholas.
Hi, I'm Nicholas. I am a part of CIRC and one of the liaisons from Peoria. Kyle, if you want to go next.
Yeah, I'm Kyle Auer, he, him pronouns, and I am with the with CIRC.
Okay, I can go next. My name is Sarah Greenberg, she, her pronouns. I am part of CIRC and also a graduate student at ISU. And I will pass it to Georgine.
Hi, my name is Georgine Chiselle, and I am a part of Afro-Socialist of Bloomington-Normal. And back to you, Zach.
Thank you so much, Georgine. And I do want to give a real quick chance for Alan Axelrod to go ahead and introduce himself real quick.
My name is Alan Axelrod, pronouns he, him. I'm a member of the Central Illinois Solidarity Research Collective. And yeah, sorry, I'm catching up on things, but solidarity with everybody, independence.
All right, thank you so much. With that, let's begin. Go ahead and go to the next slide. So I'm going to begin with our executive summary. The Illinois legislature passed a number of important criminal justice reforms in the form of HB 3653. The Central Illinois Research Collective and other organizations support these reforms. CIRC is releasing this guidance to assist local municipalities in interpreting and implementing HB 3653. Because of perfidious efforts at prevarication by opponents of this legislation, it is necessary to carefully explain what is actually included in HB 3653. We believe it is important for public officials to know that the working people of Illinois support this legislation and encourage public officials to embrace these reforms and implement them to the best of their abilities. Furthermore, public officials should be mindful that the working people of Illinois support efforts at increased police accountability, transparency, reform, and that they desire alternative institutions to address public safety. We believe if law enforcement agencies choose to embrace these changes, that it will help facilitate police-community relations and improve community trust in law enforcement. This is also an opportunity for police departments to implement changes and reforms that were suggested after the murder of George Floyd, as many departments spoke out in support of communities and wanting to build better relationships. If we go to the next slide, I'm going to go ahead and hand it over to Nicholas, who is going to give the introduction to our guidance.
So HB 3653 is also known as the SAFE-T Act, or the Illinois Safety, Accountability, Fairness, and Equity Today Act. It passed the General Assembly 60-50 and the State Senate 32-23, indicating a supermajority of support. The bill was signed into law by Governor J.B. Pritzker on February 22nd, 2021. A major portion of HB 3653 is the Pretrial Fairness Act, the abolition of money bond, which will take effect on January 1st, 2023. This date was delayed with negotiation at request of the Illinois Supreme Court and other system stakeholders to allow the court time to transition to the new system. All other provisions of the law, including police decertification, ending prison gerrymandering, body cam requirements, and the use of force changes have varying effective dates. This guidance includes all follow-up laws that alter HB 3653, including HB 3443 and the Stefan Watts Act. The following measure are included in HB 3653, and we will post a copy of the full law in the chat. I now will hand it over to Kyle Auer to talk about the different effective dates.
All right, so to kind of get started, just a quick FYI, this is over a 700-page bill, and because of such, there are a lot of changes, a lot of things that are being implemented here. So bear with me because it is a lot. So this starts July 1st, 2021. So first off, it's gives statewide use of force policy, no driver's license suspensions from failure to pay fines. If your license is currently suspended because of unpaid fines, you can go to your local DMV to get your license back. It requires maintenance of public misconduct records and requires the use of special prosecutors in officer-related deaths. Requires departments to create a policy for receiving non-notarized complaints, greater reporting to the Illinois Attorney General and federal government on deaths and use of force, complete ban on chokeholds, requires statewide standards and services for officers to receive regular mental health screenings and assistance while ensuring that counseling and screenings remain confidential, imposes upon police a duty to intervene in the excessive use of force by another officer and to render aid when necessary, and enhances whistleblower protections for officers. Next slide, please. Victims qualified for restitution regardless of criminal history. Previously, some people with criminal histories who later themselves become victims of crimes were ineligible to the restitution they deserved. There is a ban on military equipment, such as bayonets, grenade launchers, armored vehicles, weaponized aircraft, vessels or vehicles, firearms, and ammunition of 50 caliber or higher. There are changes in the parameters of no-knock warrants, requires safety plan for children and bystanders. All officers must wear body cams while serving warrants, and must verify the correct address. It also makes it a Class 3 felony for an officer to do the following: to lie about their conduct, withhold information or lie about another officer's conduct, and to not follow Illinois body cam laws. Next slide, please. It prohibits people with less than 4 months on their sentence from being imprisoned, and allows them to be diverted to EM or electronic monitoring or another DOC facility or program. It increases services and programming for pregnant prisoners and requires medical treatment of prisoners and detainees without unreasonable delay. Specifically for the Pretrial Fairness Act, there is statewide data keeping of pretrial information, and home incarceration counts towards credit regarding time served. Next slide, please. So effective as of January 1st of this year, mandates certification of police officers through the Illinois Law Enforcement and Training Standards Board and lowers threshold for decertification of officers. Previously, it was extremely difficult to decertify officers. The requirements were that officers must be convicted for a felony before they could be decertified. House Bill 3653 dramatically lowers the threshold and allows the Illinois Law Enforcement and Training Standards Board to perform its own investigations. Officers can now be decertified even if no charges were filed, but there was substantial evidence that would have led to the prosecution. This is critical because many local state's attorneys are reluctant to hold police officers accountable because they are colleagues and they work together and they have similar class interests. It expands police training on use of force and crisis intervention, as well as first aid training. Police and municipalities with populations of 500,000 or more must wear body cams. It adds new detainee rights when in police custody, including the right to make 3 free phone calls within 3 hours of arrival at the police station and before questioning occurs. The ability to retrieve phone numbers contained in their cell phone's contact list prior to the phone being placed in inventory requires prominent notice of these rights in police stations and booking rooms. It also requires that the telephone number to the public defender and or appointed attorney's office must be displayed. Specifically for the Pretrial Fairness Act, people on electronic monitoring are guaranteed movements to perform essential tasks. They're also guaranteed movements at least 2 days per week to care for loved ones and themselves. There's a review of EM restrictions by a judge every 60 days, and it requires individuals on home confinement to be in violation over 48 hours before they can be charged with a felony escape. We'll talk about more on electronic monitoring later on in this presentation. Next slide, please. So effective as of January 1st, 2023, the Pretrial Fairness Act abolishes money bail. There must now be an underlying offense for resisting arrest charges. No more I'm going to charge you with resisting arrest even though you aren't under arrest for another crime. Police have greater discretion in who they incarcerate and who they give summons to. And police and municipalities with populations of 100,000 or more, but under 500,000 must wear body cams. Next slide, please. Effective as of January 1st, 2024, police and municipalities with populations of 50,000 or more, but under 100,000 must wear body cams. Next slide, please. Effective as of January 1st, 2025, ends prison gerrymandering, the practice under the current law of counting prisoners toward a jurisdiction's census count rather than their permanent address. Police and municipalities with populations under 50,000 must wear body cams. And that is everything that is in the bill. And now I will pass it off to Alan on what this bill is not including.
So let's talk about what this act does not. It does not abolish qualified immunity. It does not place restrictions on police collective bargaining. It does not include residency requirements for officers. It does not impose financial penalties for violation of the law or failure of agency to comply with the law. It does not eliminate felony murder. Murder is still a felony, despite the misinformation that's been out there. And CIRC officially recommends all individuals abstain from committing murder. It does not eliminate charges for habitual offenders. If you frequently commit crimes, you can still be charged for those crimes. If it does not prevent you from purchasing camouflage uniforms, fully automatic weapons, silencers, drones with military grade surveillance, chemical incapacities, including or incapacitates, including tear gas and other chemical irritants. It does not prevent the use of force, and it does not require a duty to retreat. So it's just some clarity, given all the misinformation out there, what this does not do.
Okay, that would be me next. That's use of force. Use of force is an essential function of policing. The HB 3653 states a police officer need not retreat or desist from efforts to make a lawful arrest because of resistance or threatened resistance to the arrest. He is justified in the use of any force which he reasonably believes, based on the totality of the circumstances, to be necessary to affect the arrest, and of any force which he reasonably believes, based on the totality of the circumstances, to be necessary to defend himself or another from bodily harm while making the arrest. Next slide, please. Police are prohibited from using force when force involves a chokehold or any restraint above the neck that could cause asphyxiation. Force is used as a punishment, i.e. torture. Force involves kinetic projectiles aimed at a person's head, neck, back, or genitals. Force involves any discriminated discharge into a crowd. Force involves chemical irritants like pepper spray and tear gas used to disperse crowds unless the crowd is given sufficient warning and time to disperse. Does not apply if there is a belief such time would unduly harm an officer. Next slide, please. Use of lethal force. An officer is justified in using lethal force when such force is necessary to prevent death or bodily harm to himself or such other person, or a fleeing subject who committed a forcible felony is likely to cause great bodily harm. Next slide, please. An officer is not justified in using lethal force when a person is only a danger to themselves and not others, or a person whose only suspected crime is a property crime, unless that crime is terrorism. When there is no longer an imminent threat of great bodily harm to the officer or another.
All right, I'm going to go ahead and go over. These are our official recommendations. The first is to develop clear procedures for cite and release practices, empower police and civilian review boards to accept anonymous police complaints and properly investigate complaints, begin the work to fully fund and expand pretrial service departments, initiate a hiring freeze of corrections officers or other jail staff, and invest in alternative first responders and deflection programs. And I'm going to go ahead and hand it over to Nicholas, if we could also get the next slide, and he's going to talk to us about cite and release practices.
Yeah. All right, so we're encouraging law enforcement agencies to consolidate and affirm their procedures for citing and releasing those accused of Class B and C traffic and criminal misdemeanor offenses, or of petty and business offenses who pose no obvious threat to community or any person, or who have no obvious medical or mental health issues that pose a risk to their own safety. Citation in lieu of arrest authorizes law enforcement to release a subject in appropriate nonviolent cases with a date to appear in court rather than being subjected to formalized arrest and booking procedures. This quote is from the Illinois Supreme Court's Commission on Pretrial Practices. Next slide, please. During the COVID-19 pandemic, law enforcement agencies have utilized cite and release procedures to help mitigate the spread of novel coronavirus, revealing that incarceration for every crime is not essential. HB 3653 allows the police to release the person after they have identified who the person is and given them a notice to appear in court within 21 days. It provides an exception that law enforcement may detain someone overnight if they pose an obvious threat to public safety or have obvious medical or mental health needs that pose a risk to their own safety. The law allows law enforcement to release any persons charged with an offense that is not detainable under the law from the station with a court date. If released is in the public interest, then this allows, but does not require police to release people charged with the most nonviolent felonies and misdemeanors. You can go to the next slide. With the abolition of cash bail, a limited number of felonies and 2 misdemeanors will be eligible for detention after a first arrest if the state proves that the arrested person poses a specific, real, and present threat to someone else. These detainable charges are things like all non-probational forcible felonies. The most common of these are murder, attempted murder, armed robbery, home invasion, and vehicular hijacking. All sex crimes, criminal sexual assault, criminal sexual abuse, child pornography related charges, various charges relating to sexual misconduct of children and human trafficking, all domestic violence charges, misdemeanor and felony domestic battery, and violations of orders of protections, all non-probational gun-related felonies, including all forms of discharge of a firearm, sale of a firearm, and most forms of possession of a firearm. All new arrests when someone is on pretrial release or probation, and any serious felony where there is a high likelihood of willful flight. Cite and release practices will reduce the time any individual's liberty is being threatened by the state, reduce the time spent by officers on frivolous or banal uses of their time, and decrease the safety risks caused by arrest, transportation, booking, and incarceration for both defendants, police, and corrections staff. Further, the citation procedure limits the necessity for pretrial services and court involvement prior to release. These benefits will allow law enforcement agencies to prioritize more serious criminal offenses and allow local municipalities to save resources. Public officials should direct their police department to implement cite and release policies that allow officers to cite and release individuals charged with certain crimes. They should direct police departments to apply cite and release to as broad a range of crimes as possible, with exceptions to those detainable charges listed in HB 3653. And they should implement and expand cite and release now. I am now going to hand this over to Georgine to talk about the officer complaint policies.
Officer complaint policy. The law removes an outdated measure that forces residents in Illinois to sign a sworn affidavit in order to file a complaint against a police officer. The threat of being prosecuted for making a complaint, if even one material fact is not accurate, has discouraged many people from leveling legitimate charges against officers who have abused their authority. Law enforcement agencies and police civilian review boards or their equivalent should immediately create a policy for accepting and processing complaints without the requirement for a sworn affidavit, including processing anonymous complaints. Next slide, please. Previously, police complaints were permanently destroyed after 3 years. With HB 3653, all public records and non-public records related to complaints, investigations, and adjudications of police misconduct shall be permanently retained and may not be destroyed. The new officer complaint policies were effective July 1st of 2021 and should be in place at this time. Next slide, please. Public officials should check with their police and or sheriff's department to confirm these policies are in place. I'll hand it back over to our next presenter.
All right, so now we're going to talk about the pretrial services departments. So we encourage county boards to immediately begin the process of fully funding a pretrial services department and its additional responsibilities. A pretrial services department is responsible for interviewing and screening all defendants before their court appearance to determine their eligibility for pretrial detention. Information derived from a pretrial interview, such as community ties, residency, employment, history of drug and alcohol abuse, and physical or mental behavioral health conditions, provide additional information that assists the courts in making informed bail decisions. To quote the bill, decisions regarding release, conditions of release, and detention prior trial should be individualized, and no single factor or standard should be used exclusively to make a condition or detention decision. Next slide, please. According to the Illinois Supreme Court's Commission on Pretrial Practices, quote, once an individual is ordered to pretrial supervision, pretrial services agencies shall meet with the individual to review the court-ordered conditions, establish expectations during pretrial supervision, answer questions, and review future court appointments. Pretrial services agencies shall monitor and maintain records of defendants' compliance with the conditions of release. Pretrial services agencies shall implement a system of court date reminders, including location, date, time of the court appearance. Reminders should be provided 1 to 3 days prior to each scheduled court appearance. Other services include check-ins, drug tests, electronic monitoring, and assisting people with transportation. We discourage the use of electronic monitoring and drug tests, as these are often tools for surveillance and punishment in the guise of services. Next slide, please. Proponents of cash bail have frequently relied on the anecdotal evidence of failures of abolishing cash bail by referencing specifically New York and California. However, New Jersey, again quoting the Illinois Supreme Court Commission on Pretrial Practices, quote, also overhauled its bail system in order to reduce the reliance on cash bail. Criminal Justice Reform Act, passed in 2014 but not implemented until 2017, enacted sweeping systemic changes. Under New Jersey's new system, all defendants other than those facing life imprisonment are entitled to presumption of release. Pretrial detention is only allowed where a prosecutor convinces a judge that no conditions could protect the public or ensure that the defendant will return to court. At these hearings, defendants are represented by counsel, can call and cross-examine witnesses, and receive all the same information the prosecutor has. Since implementation, New Jersey has seen a dramatic reduction in pretrial jail populations, while failure to appear and rearrest rates have largely remained the same. Next slide, please. Furthermore, the law creates a distinction between willful flight, which is an intentionally avoiding trial, and simple failure to appear. Should someone unintentionally miss a court date, the Pretrial Fairness Act also reforms the warrant process. Previously, a judge must issue a warrant for immediate arrest. With HB 3653, the individual will be notified and given the chance to appear voluntarily, avoiding unnecessary arrests and saving valuable court and jail resources. We do not believe that failure to appear rates will increase with the abolition of cash bail. According to the Journal of American Judges Association, in 2012, a report on the Jefferson County, Nebraska failure to appear project and resulting court date notification program found that when defendants were reminded of their court dates, their court appearance rates increased from 79 to 88%. Therefore, we recommend that judicial districts create protocols for court reminders, including emails, text messages, calls, etc. We also recommend transportation assistance to and from courts be provided to those individuals needing it. County jails consistently have a pretrial population of 90%. With the abolition of cash bail, we expect those numbers to decrease. Next slide, please. County boards should initiate a hiring freeze of corrections officers and other jail staff. The board should not fill vacancies left by retirements. The money saved should be invested in the pretrial services department to maximize its success. Implementing pretrial supervision will require commitment to sufficient staffing and other resources. County boards should also verify that sheriffs are promptly implementing the new phone privileges and pregnant inmate protections as mandated by law. And now I will pass it over to Sarah to talk about electronic monitoring.
Okay, so I will be talking about electronic monitoring. I'll start with a quote from the Illinois Supreme Court Commission on the Pretrial Practices. Electronic monitoring is available for pretrial supervision. However, its use should be limited and specific to a condition that requires close monitoring. And should electronic monitoring be ordered as a condition of release, no defendant shall remain in jail or have their supervision revoked due to their inability to pay electronic monitoring fees. So what is electronic monitoring? Electronic monitoring is the practice of releasing individuals pre-trial, but confining them to their homes. House arrest is another form of incarceration. It still destabilizes lives and families. It also prevents incarcerated individuals from doing basic tasks like grocery shopping, working, and seeking medical care. Next slide, please. The Pretrial Fairness Act does not abolish electronic monitoring, but it does place a number of important restrictions on its use that protect the rights of those subjected to it. First, it guarantees freedom of movement to accomplish those essential tasks that I talked about. Grocery shopping, doctor's visits, attending job interviews, this kind of thing. It does require mandatory judicial review of electronic monitoring restrictions. That's every 60 days to redetermine if electronic monitoring is still necessary to both protect the public and also guarantee a person's appearance to trial. The Pretrial Fairness Act recognizes that electronic monitoring is still incarceration by another name. Incarcerated individuals pre-trial currently receive time served or credit towards their sentence if convicted, and courts are now required to include house incarceration as credit towards a person's punishment. People incarcerated at home have faced legal harassment and abuse for incidental or technical violations. So HB 3653 decrees that if a person incarcerated at home is in violation of their conditions, they can't be charged with felony escape unless the violation is longer than 48 hours. So that's a significant change. This ensures a person will not receive a felony charge for a minor, technical, and sometimes an accidental violation of electronic monitoring. The policy maintains the difference between willful flight and mere failure to appear, even for inmates on electronic monitoring restrictions. Next slide. Public officials should review what companies judicial districts are contracting with to provide the surveillance equipment used with electronic monitoring. We think they should also review any fees associated with electronic monitoring and do everything they can in their power to reduce the fees or any debt that would be associated with those fees. And that is it on electronic monitoring. I will now pass it to Zach to talk about risk assessment tools.
Thank you so much, Sarah. So risk assessment tools, also known as RATs, according to HB 3653, quote, risk assessment tools may not be used as the sole basis to deny pretrial release. If a risk assessment tool is used, the defendant's counsel shall be provided the information and scoring system of the risk assessment tool used to arrive at the determination. The defendant retains the right to challenge the validity of risk assessment tools used by the court and to present evidence relevant to the defendant's challenge. Next slide, please. RATs are algorithmic tools that use historical data to determine what a person's quote unquote risk of failing to appear at court are. According to the National Association of Criminal Defense Lawyers, while RATs are often touted as capable of predicting individual behavior, quote, the tools are actually incapable of making individualized predictions. This is because they study data from many individuals and then forecast aggregate group risk. A risk score, therefore, indicates that a person shares traits with a group who succeeded or failed at appearing to court at a certain rate. But the score provides no information about how a specific individual will behave if released. Because RATs rely on historical data which has been historically biased racially, these tools actually contribute to the racial disparities we see in the criminal justice system. Next slide, please. Again, quoting the National Association of Criminal Defense Lawyers, quote, stereotypes, whether by people or algorithms, are necessarily overbroad and intentionally blind to the individual. Being wrongly labeled quote unquote high risk under these circumstances is particularly unsettling since, if detained, these arrestees likely can never prove that they are false positives. This is really important. We know that defendants that are detained pretrial have worse outcomes to their cases than defendants released pretrial. So by relying on algorithms, especially ones where it's not transparent how these decisions are being made, you could potentially be stacking the deck against defendants and therefore violating their due process rights. HB 3653 does provide a robust individualized hearing process for determining pretrial release. We recommend this be used without reliance on risk assessment tools or RATs. Next slide, please. Public officials should determine what corporations are providing their judicial districts with risk assessment tools. How much is being paid for access to this software? What is the efficacy of their specific brand of tools? How transparent are these companies? How transparent are these companies when it comes to how their RATs work? What is the algorithm they're using? These are all very important questions that public officials need to understand in order to understand risk assessment tools. And I'm going to go ahead and send it over back to Sarah, and she's going to talk about alternative first responders.
Okay, so HB 3653 amends the Deflection Act by adding other first responder and co-responder language. The law provides access to Illinois Criminal Justice Information Authority, or the ICJIA, funds for the purpose of development and implementation of collaborative deflection programs for both substance use treatment and other services as an alternative to traditional criminal justice involvement. The amendment makes clear that these deflection programs are available for other first responders and co-responders. These funds are only available to first responders employed by municipalities. Funding for deflection programs is prioritized for communities that have been impacted by the war on drugs, communities that have police or community relationship issues, and communities that have a disproportionate lack of access to both mental health and drug treatment. Deflection programs facilitate contact between the individuals and licensed substance use treatment providers or mental health professionals with the purpose of avoiding incarceration or institutionalization. These programs must include procedures for participant identification, also screening or assessment, treatment facilitation, reporting, and ongoing law enforcement involvement as well. These programs also include, but are not limited to, post-overdose deflection, self-referral deflection, and active outreach deflection. So we all recommend that municipalities develop working relationships with local providers who can offer these services and also be on call. The law encourages co-responder approaches that incorporate behavioral health, peer or social work professionals with law enforcement or other first responders at the scene. Next slide. However, the Community Emergency Services and Support Act, CESA, signed into law of last year, 2021, prohibits police from responding to nonviolent or non-criminal mental and behavioral health calls unless no other alternative responders are available. So with the passage of CESA, crisis teams must be dispatched to all nonviolent, non-criminal, mental and behavioral incidents without police presence to prevent unnecessary escalation. Though police may be stationed in the vicinity, like at a distance or out of sight, so that they can still rapidly respond to requests for assistance by a crisis team if they are needed. Next slide. CESA provides for mobile mental and behavioral health support without the involvement of law enforcement involvement. Its focus is on activity separate from the activity regulated in the Deflection Act. The mobile response transportation system provided under CESA pertains explicitly to the non-criminal emergencies in which law enforcement involvement is prohibited. The Deflection Act explicitly pertains to law enforcement involvement in criminal situations. HB 3653 and CESA do not conflict and they do complement each other. Next slide. So our collective recommends the creation of mobile response units composed of crisis teams of both first responders licensed by the Department of Human Services. Each crisis team should include at least one medic and at least one mental health or crisis response professional. The fact that an individual is experiencing a mental or behavioral health emergency or that an individual has a disability diagnosis should not be sufficient to justify an assessment of threat to public safety to support a law enforcement response to a request for emergency response or medical transportation. Public officials should use alternative responder models to address nonviolent, non-criminal calls for service that are not limited to mental or behavioral health concerns. And this would allow law enforcement agencies to prioritize more serious criminal offenses and also allow local municipalities to save their resources. Any incident where criminal activity is present but could be held in abeyance pending engagement with treatment can include a co-responder model where crisis teams and law enforcement are the first on the scene. And Nicholas will now be talking about the review of our action guide.
All right. So with Sarah's section over, that concludes our recommendations regarding HB 3653. Before we begin a short question and answer session, CIRC has created an action guide for organizers that we're going to drop in the chat that support HB 3653. And if you would like to promote the bill in your own community, organizations wishing to co-sign to the HB 3653 guidance should review our action guide on best practices for promoting the guidance. The first step is identifying the power players in your community. Who would be responsible for implementing HB 3653 at the local level. This will include your city council members, police chiefs, county board members, sheriffs, and state's attorneys. This is called power mapping and is a necessary tool for any organizer. Once you know who and how to contact the power players in your community, let them know how you feel about HB 3653. Send them a copy of CIRC's official guidance. If you are an individual, submit a letter to the editor piece in your local newspaper. Organizations should issue press releases stating their public support for HB 3653 and the recommendations contained within the guidance. If your organization has capacity, give public comments at your city council or county board meeting. All gatherings of public bodies must contain a section of their agenda dedicated to public comments. Express your opinions directly to the public officials who work for we the people. Read out the recommendations of the guidance and enter it into the official public record. And finally, talk to your friends and family about HB 3653, why CIRC recommendations are important, move them to action through social media and through email. We are now going to hand it over to Zach to open up for Q&A.
Okay, thank you so much, Nicholas. We have opened up the chat, so if you do have any questions, we only have a couple minutes left, but go ahead and post them in the chat and we will try and answer them to the best of our abilities. So we'll give a couple minutes to see if there are any questions. Any questions whatsoever? Okay, so it looks like our first question is, would you mind clarifying if this law defunds the police? So there's a couple of different ways of answering this. Did the legislators who put this bill in place, do they support defunding the police? Well, most of them have said no. So they do not believe that this law defunds the police. Most of this bill is reformist. It seeks to change the already existing institution in order to make it better. However, there are some really important things that will have the effect of defunding the police. And by defunding the police, we mean taking responsibilities away from the police and as well as resources at the same time. So a couple of good examples is the abolition of cash bail. If we have less people that are being incarcerated pre-trial, then that means that we will have less of a need for corrections officers. So that will create less responsibilities for them and open up funds for other things. Same thing with cite and release practices. The fact that every arrest that an officer makes can take multiple hours to actually process, whether it is filling out paperwork, transportation, actually incarcerating the individual. If a cite and release might take just a half hour, so that would dramatically decrease the amount of time that police are focusing on relatively minor offenses. And also at the same time, it will also increase safety for officers, because when you put handcuffs on somebody, if you ask police departments, that's one of the single most dangerous times it is to be a police officer, is when you're about to take away someone's freedom. And I know that they focus a lot on that part of training. So cite and release allows the possibility where we can avoid that altogether. And so most of this law is reformist, but some of this law will have the effect of taking responsibilities away from law enforcement. And therefore, we can take away some resources at the same time, because we do not support austerity. Austerity is when you cut someone's budget, but you don't change any of the responsibilities they have, or you add responsibilities. And that's not what we support. So that's my answer to that. We do have a question from Mr. Garcia. He says, how do you reconcile the alt response model and funding needs with local Bloomington Police Department preference for co-response models? Seems we have a local disconnect. I can also answer that the CESA, the Stefan Watts Act that was passed, it gets around any preferences that they might have for co-response models involving anything that is non-violent, non-criminal, mental or behavioral health. So the law is very, very clear. Unless there's literally no one else that can handle that type of call for service, then police are not supposed to be sent out to those situations. As far as co-response models, we do know that a lot of police departments want to continue or want to start using co-response models where they themselves will also be the first on the scene. We've already talked about how there are certain situations that go beyond CESA that that we think would be better with alternative responders, which means that the police officer is not the first responder on the scene and therefore is not necessarily in charge of that scene. Things like issuing death notifications, wellness checks. There's all sorts of situations that armed police officers are currently responding to that we could better utilize those resources by sending alt responders. And it looks like we don't have any other questions. So I'm going to go ahead and hand it over to Kyle.
It looks like we had another question in the chat.
Most crimes are not victimless. How does this law impede or coexist with the Victims Bill of Rights? Yeah, I mean, this does not conflict with any of the any victims' rights whatsoever. I will point out that when this legislation was being written, domestic abuse organizations were at the table. They were involved in writing this bill, and they support this bill because we took their concerns into account. So one last thing. The last question is, are there alternate ways to get mental health responses in an emergency other than 911? That's an excellent question. There is a new 3-digit number called 988 that will soon be going into effect within the next year. And this is going to be huge. This is going to be able to handle, right now, if you call 911, and the 911 dispatchers do an amazing job, but their job is specifically to dispatch. The 988 number that will be coming in, that it will be essentially the National Suicide Hotline. That number, which would be the one sending out any alt responders, will hopefully be trained in a way that they could handle the majority of the calls over the phone. And that will save an enormous amount of resources, and while at the same time getting people the help that they need without resorting to violence or threat of violence. So finally, I'm going to go ahead and end the question answering and give our outro over to Kyle.
All right, so as Zach said, we're going to pause questions about the bill. And if you have any unanswered questions, please don't hesitate to send an email to CIRC at CISolidarity@gmail.com. We want to thank all of you community members, allied organizations, and elected officials for attending this virtual town hall this Saturday. We believe that understanding and promoting proper implementation of this bill will impact communities around Illinois in a positive way. We also know how important it is to hold our officials responsible for ensuring that the justice this bill promotes. In case you would like to review or watch this recorded session, it will be uploaded on social media platforms and sent out via email you are registered with. We hope that you will share the resource with others. Lastly, don't forget to revisit the action step guide that we have created to guide you in your next steps. The success of this process depends on getting the word out about the bill to everyone we can. I hope you have a great rest of your weekend.
Thank you, everyone. That concludes our meeting, and I do want to give a special thank to Afro-Soc for co-hosting this event with us. And thank you so much. Again, if you have any questions, feel free to email us.
Thank you.
Thank you.